Peter, nice to see you again. It's been a while
Okay.
since we did one of these. Time flies, but here we are again. In today's discussion, Peter is the expert. I'm the sort of pretender because our topic is we want to discuss a particular case, but it has to do with international tax and double tax treaties. And Peter is a South African expert on international tax. I don't know that I should necessarily limit it to South Africa. He's an international tax expert, but I have heard him on more than one occasion say that there is actually no such thing as income tax. I mean, as international tax. So maybe he can explain that for us. Peter, do you want to kick off with just why this is important, or I can do that?
Yeah, I think so. It's basically, as you said, talking about Jonathan Oppenheimer's case. And the case really turned on the question of double tax treaties and tax residence under the double tax treaties. And the question really was under the DTA between South Africa and the UK, whether Jonathan Oppenheimer was a resident of the UK or was a resident of South Africa. And I think your point, Trevor, chatting earlier, was that obviously trumps our domestic law definitions of residence because it's a double tax agreement. So, you know, whatever we say in terms of South African domestic law, the double tax agreement will prevail over that. And just starting with the double tax agreement, the definition of a resident, or the article dealing with residence, is Article 4. And Article 4.1 talks about the normal situation of residence. So it says you are a resident of a contracting state if you're liable to tax in that contracting state by virtue of, in this case, domicile or residence, because we're talking about an individual. And the problem here was that Jonathan Oppenheimer was a resident in terms of domestic law, both in the UK and in South Africa. And so that brought us to the tiebreaker test in terms of Article 4 in brackets 2. So I think that sort of sets the context a bit, Trevor.
Yeah. Can I just read from our definition of resident?
It's a complicated definition, that, eh?
It is, but you know, but there's a simple way out if it fits your circumstances. And you know, just anecdotally, I knew a couple who were English, but they were living in Cape Town. They bought a house here, and the husband had made a lot of money, which was in the UK, and he used to come and visit his wife and everything, but he didn't want to spend too much time here because he didn't want all of his UK assets, the income from his UK assets, to be taxed in South Africa. He's happy to pay tax on his South African source income. Until I bumped into him and I said to him, look, you know, if your center of vital interest is in the UK, then you don't need to worry. And then he started living with his wife again. So it can have very practical sort of homely sort of implications. But we got out our definition of resident, which talks about, in the case of an individual, being ordinarily resident in the Republic, or there's the number of days. But what I think a lot of people don't realize is that right at or towards the end of the definition, it says, but does not include any person who is deemed to be exclusively a resident of another country for purposes of the application of any agreement entered into between the governments of the Republic and any other country for the avoidance of double taxation. So if in terms of a double taxation agreement, you are considered in terms of that agreement to be ordinarily resident only in that other country, then whatever else goes before that doesn't matter. So it is of great practical significance to a number of people who might have a center of vital interests offshore.
It absolutely. And just coming to the tiebreaker test, because it's an interesting test in the double tax agreement, and it's multi-tiered. So it starts off saying, look, if you're resident under South African domestic law for tax purposes and you're resident in the UK under their domestic law, then let's set out a tiebreaker. So the first point of the tiebreaker is, where do you have a permanent home? If you have a permanent home only in one of those jurisdictions, then that's the place that wins the tiebreaker. But if you have a permanent home in both of those locations, then you have to look at, Trevor, as you described, your center of vital interest, which is the place where your personal and economic relations are the closer. And if you can't determine that, if that's not determinative, then you look at the place where you have an habitual abode. And if that's not determinative, then you look at the place where you are a national, so where you a citizen. And if that's not determinative, then they kind of give up and they say, well, then let's go to mutual agreement, which means we'll send it to the competent authorities and we'll get back to you in 10 years' time. So it's a multi-tiered test, this one. And I think on the facts, Jonathan Oppenheimer had a permanent home in both locations. He had a place called Folly Farm in the UK that he spent time at, and he was at a permanent home there. And then it had a permanent home in Isibindi, which I understand used to be Ananda. So he had a permanent home in both. So I said, well, that's not going to help us. We need to now go to the center of vital interest and determine in which jurisdiction his personal and economic relations were the closer. And that center of vital interest, Trevor, that took up a lot of the judgment, because he had a lot of personal interest and a lot of economic interests as well.
Absolutely. I mean, the judgment is very interesting to read just from that point of view as well. But I've got Article 4 of the Double Tax Agreement in front of me here, and it says, blah, 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 where the provisions of paragraph one of this article is a resident of both states, then that individual's status shall be determined in accordance with the following rules. A, the individual shall be deemed to be a resident solely of the contracting state in which a permanent home is available, as you've just said. And if a permanent home is available to the individual in both states, which was the case of Jonathan Oppenheimer, the individual shall be deemed to be a resident solely of the state with which the individual's personal and economic relations are closer. And then in brackets, center of vital interest. Yes. So the point I'm trying to make, perhaps in a long-winded way, is that it's the individual's personal and economic relations are closer to one or other of the countries. And that is what the term center of vital interest means. So you don't only look at economic relations, you look at personal relations as well. And, I think a very instructive thing about this case is just how much depth they went into.
Enormous depth. It's super interesting. I mean, even as a layman reading it, the lives of the rich and famous. But before I come on to that, just the center of vital interest, as you say, Trevor, you look at your family and social relations, you look at your occupations, you look at your political interests, you look at your cultural interests or other activities. And we have someone like Jonathan Oppenheimer, who has got significant family interests, social interests. He has multiple occupations. He's politically active as well, more in South Africa than the UK, which is interesting. And you have a lot of cultural activities going on as well. This took a lot of time to sort of unpack his life and his lifestyle and to work out where his center of vital interest was. And as I was sort of teasing about the lives of the rich and famous, but they sort of point out he spent weekends. You could spend one weekend in London and the next weekend in Cape Town. So,
and he also flew his own aircraft, so he could fly himself.
So as I say, it's sort of it's a very old-fashioned test, but it's interesting when applied to the facts of a very modern man. They still came to what I felt like was the right result, because it was such a rigorous analysis of all of those different aspects of his life that you felt on balance when you read it that they came to the right conclusion, even though, as I said, it's a very old test and a very modern lifestyle.
I mean, he really was, I don't know, I don't think either of us mix in these circles, and I'm quite happy about that. But I mean, he could walk into his home in Isibindi, as you say, or on Folly's farm, and there'd be 8 staff there, probably similar food in the fridge. He could walk in and just carry on doing whatever he's doing. It made no difference whatsoever. And also he had strong links with, obviously, South Africa, where his family came from, and etc. And with the UK, but also with America, because a prominent feature of the judgment is his wife. His wife was American, and I think they had 3 children, and the one child was educated in the United States. So they spent time in all 3 countries. And what's a very significant aspect of that judgment is that I probably spent the least amount of time in South Africa, and yet it was South Africa that was held to be his center of vital interest. So it's not a time-based thing.
It's not a time-based thing. And if he'd lost on center of vital interest, he would have lost, because that's quite high up in the tiebreaker test after permanent home. So it was very important that he won on center of vital interest, or if they couldn't determine center of vital interest and they went to place of habitual abode, it was admitted that he had a place of habitual abode in the UK. So then he would have had to prove that his real habitual abode was South Africa in order to win in the tiebreaker. And he was only a national of South Africa. So if he got to that second last point in the tiebreaker, he would have won. South Africa would have won, if you like, because he was only a national or citizen of South Africa. But the center of vital interest was very important, heavily documented, analyzed, rigorously tested. And I don't want to get the cat out of the bag at this fairly early stage, but it was held that a center of vital interest was in fact in South Africa, as I think you alluded to, and not the UK. But the courts were, that was an excellent judgment, I must say. I enjoyed reading it, because they said, well, if we're wrong, let's go on to habitual abode and let's see where we end up on that basis, because we know there's an habitual abode in the UK, but let's see if he also has one in South Africa. And as you said, habitual abode, it's not a time-based test, which you would think it would be. I mean, where's your habitual abode? Where do you spend more time? But that's not all that they look at. They say, where are you customarily or usually present in terms of habitual abode? And again, there was quite a lot of analysis about where he was customarily and usually present. Was it in Isibindi or was it in Foddy's farm? And again, they hold that they thought he did have an habitual abode in South Africa. So even if they were wrong on center of vital interest, he had an habitual abode in South Africa, and he was only a national in South Africa. So again, South Africa, strike 2, would be the place to which he defaulted as a resident.
Can I just read very briefly from what we published in the Taxpayer? This is the findings part of the head note, which may be of some assistance, and it comes obviously straight from the judgment. The word vital in the phrase center of vital interests means necessary or essential, which could be defined as being the things that were of the greatest importance to the taxpayer. It was therefore necessary to establish the facts about Mr. Oppenheimer's thinking, which introduced a subjective element to the test. So I think that's very important. What was important to him, his economic relations and his personal relations. Mm-hmm. Then Article 4.2a embodied a composite test. And in each instance, it would be a matter of fact and degree as to whether a taxpayer's personal and economic relations viewed as a whole supported ties closer to one contracting state rather than another. And then this is quite interesting. When considering habitual abode, one should look at whether living in each country was normal, and the test should not merely be applied for 1 year, but a broad view should be taken over a number of years as to whether living in each country was habitual. Point number 5, Article 4 of the DT Double Tax Convention was about relations, which signified connections. And the questions to be asked were more about who and what than about when or where, which I think also emphasizes the subjective element of the thing. So you could have 2 people who had very similar circumstances, but because of the subjective element, one might come to different answers.
It's interesting. And I think another sort of aspect of the case, which brings in sort of a wider application, is it talked about this concept of international tax, which, as you know, Trevor, doesn't exist. You have domestic tax, South African tax, and you have UK tax, and you have public international law, which is in the form of a double tax agreement. There's no international tax. There's no like body of tax that sort of sits above domestic law. You just have double tax agreements. And how do you interpret them? And the court again confirmed, you go to the good old Vienna Convention, 1969, together with the OECD commentary. And it also referred us to the Anson case and the Fowler case. And it said, when you're looking at a treaty and reading a treaty, you must look at its ordinary meaning. You must look at the context and the light of the DTA's object and purpose, which, Trevor, is pretty close to Indomani. You know, if you think to Judge Wallace's sort of lovely judgment, where he said, when you interpret South African legislation, you look at the language, the context, and the purpose. And again, sort of the international law sort of issues, what I just said, you look at the ordinary meaning in their context, and you look at the light, you look at them in the context and light of the DTA's object and purpose. So quite similar ways of reading domestic tax law and reading a treaty. You look at the object and purpose, and in this case, confirm that approach, which has been with us since the Vienna Convention, as I said, through the OECD commentary. And I like the way it sort of ties quite closely to our domestic law concept, I think.
Oh. Maybe I can just mention some of the headings in the judgment, which is not our headings, they're the judge's headings. So she deals with the property portfolio and matters directly associated therewith. And just before I carry on, another interesting aspect is that all of these assets were not always held by Jonathan Oppenheimer personally. They were held via trusts and other entities, but the court took a very holistic approach to the whole thing. But they discussed Folly Farm, which was his UK residence, and where the funding for that came from. They discussed his London flat. They discussed Tswalu, which is in the in South Africa, which was very important to him. Leopard Creek, which I understand is a golfing estate. Then they discussed non-working activities. They looked at his flying activities. They looked at his shooting. They looked at golf. They looked at cricket. They looked at squash. They looked at what clubs he belonged to, politics, health, his paid and unpaid employment history. And I mean, it just goes on and on, but it's very interesting to read. Then they discussed the day counts and all of that, which turned out to be not that significant. Mm. And if I can just mention what I think is key to the thing, it's in paragraph 338. Now that tells you what a long judgment it is, but it's a pleasure to read. It's not. I'd encourage anyone to read it. What was important to Mr. Oppenheimer? What was important to Mr. Oppenheimer in the relevant period? Undoubtedly, his wife and children. But just as they would rarely have been out of his thoughts, we find that the Republic of South Africa, its people, its culture, its politics, its place in Africa and in the world would rarely have been out of his thoughts. The same could not be said for the UK. Although, of course, he has friends in the UK, his closer links with his friendship base was with South Africa, and it was interlinked with his various obligations. His political interests were closer to the RSA, and so on. So I think that gives a summary of it. So, you know, even though he spent a lot less time in South Africa, this you know, you'd almost you couldn't say, well, what's the place he would return to from his wanderings? But this was, you know, his relations with South Africa never ended. They were always there.
It's a lovely summary that. And interesting, just giving some background to the UK, because the UK, so if you go to the UK and you become resident or ordinarily resident there, you only taxed on your UK sourced income and income that you remit to the UK. So it's effectively has a very nice tax system for wealthy people. They can go and live in the UK, English language, etc., terrible weather, but we all know that. And they can keep their wealth offshore.
Can't play rugby, we all know that as well.
And you're only taxed on what you remit to the UK, which we all know Richie Sunak's wife has taken advantage of that, and he's taking a bit of political heat about this fact that his wife has taken advantage of it. But that's been part of their tax law for a very long time. So it's a very attractive place for people to go and live. Doesn't mean that your heart's going to go with you, Trevor. I think that's what the judgment was going to say. Your heart may well remain in South Africa. And if you're wealthy enough to be able to come back here at the drop of a hat you're going to come back here and you're going to find that your center of vital interests probably are linked here. And it's interesting what they said. He was very involved in politics, but only South African politics, not UK politics. So, I think that was quite telling. But, you can see, as I say, you understand why people go to the UK. There's a very strong tax pull to go there if you're a wealthy individual.
Is that what they call being a non-dom?
Res non-dom, exactly. So as soon as you become domiciled, when you're domiciled, it's all over. Then you tax on your worldwide income in the UK. So you tread this line between being resident but not domiciled. And they've had that status for a very long time through Labour governments, Conservative governments. So, and a lot of people who take advantage of that. So,
and in this case, in the Oppenheimer case, which, by the way, was held, the forum in which it was held was it's called the Tax Tribunal. It's the very first port of call, presided over by a judge. It was Judge Scott. And I think she's, I can't see this case going on appeal. I think she's written a pretty unappealable judgment. Who knows? But I think it's a very good judgment. It strikes me as being correct. But interestingly, and maybe you can shed some light on this, what was in issue here was income that Jonathan Oppenheimer received from the Harry Oppenheimer Trust. And it suited him to be treaty resident in South Africa rather than the UK.
Exactly. And I think the UK needed him to be resident under the treaty for them to have taxing rights. I think that was the nub of it. So they needed to get the taxing rights that they wanted. They needed him to be resident for treaty purposes in the UK, which is what, why the whole case was so important. And significant amounts at stake, significant remittances made to him from the trust over the relevant years, as you'd expect. So there was a lot at stake here. I think just another sort of interesting sort of point, which is again a general point, is that the court looked at the OECD commentary and it said the OECD commentary post-dates the DTA. The DTA is 2003 DTA. And it says, how do we do this? How do we deal with this? And it depends whether you follow an ambulatory or static approach. If you follow the static approach, you go to the OECD commentary at the time of your treaty, which is 2003. If you follow the ambulatory, then you look at the most recent OECD commentary, even though it post-dates the DTA. In this case, they followed the ambulatory, so they looked at the latest version of the commentary. And they said, we know it's a bit unfair because the treaty was entered into many years before the commentary, but we're only going to give it persuasive influence. So it's not going to be binding on us, not going to be determinative, but let's read it and see what it says, which I thought was, again, quite sensible. They pointed out that South Africa is not a member of the OECD, but we are aware of the commentary, which is nice of them. We are certainly aware of the OECD commentary, and we're actually a very active non-member of the OECD. South Africa is very, very close to the OECD, and we do follow their publications, languages, commentary, etc. So we're not a member officially, but I think you can almost see us as a quasi-member in terms of how we follow that the OECD sort of guidelines.
I seem to remember somewhere in our act, there's a reference to the OECD.
That's true. There are a few definitions that reference the OECD definitions, like permanent establishment, etc. So yeah,
that's where it is.
I think it also, I think you touched on Trevor, like they described him as having a peripatetic life, which I think is a good description, and the fact that he is, aren't we all, between Luxembourg and Ireland and South Africa and the UK, and but I think, on a more serious note, it ties into sort of the concept of effective management, and effective management is very hard to pin down in the modern world. And often we talk to clients and we say, the effective management, where were you when you took this decision? They say, hey, look at you, like, where was I? I was probably on a plane. I mean, I travel so frequently. I can't tell you where I was, because for effective management, you look at where the person was at the time that they took the relevant decision for the company. And often they say, I can't tell you where I was. I can tell you where I was at the board meeting, but that's not really the test. It's a question of substance. Where were you when that decision was in substance taken? said, well, I was probably on a plane, So I think, again, our concepts of effective management are becoming quite old-fashioned in this very modern and now post-COVID world where everyone's on planes again and traveling all over the place. So I think in this case sort of illustrates that, and the modern life is not well suited to the old-fashioned tax concepts of, for example, effective management.
Yes, because assuming that there's one person whose decision is like a majority shareholder or something like that, just speaking for myself in my own very mundane and insignificant way, thoughts crop up in the strangest places and at the strangest times. You sometimes wake up and you've dreamt the answer to something.
Exactly.
And you find out it wasn't correct, but anyway.
Yeah, and if you sort of imagine that Jakkelsfontein is London and Cape Town is Cape Town, but you, Trevor, are between the two all the time, you can see how difficult that effective management decision or discussion would be in your case. And we have a lot of clients who they just travel constantly between countries. It's an ongoing wrestling match, I think, and it shows how important tax planning is and thinking in advance about these things before you get to court. And I'm not sure how much advice he took. How much advice can you give a guy like this? He's traveling all over the place. But, I think, you think maybe with hindsight, he could have been a bit more careful about some of these points and avoided the court case.
Yeah, but one of the issues in relation to ordinarily resident, one of the unresolved issues, the Cohen's case and then Catel's case, I think is more or less settled what it means. But there's still a question, can you be ordinarily a resident in more than one place at the same time? And an example that always used to occur to me was when Judge Corbett was the Chief Justice. He'd obviously be working in Bloemfontein, and he had a residence there, an official residence. But when court wasn't in session, he would be in Cape Town. So certainly both of those would have been habitual abodes. And it's perhaps a bit old-fashioned to think that you can only have one place where you're ordinarily resident. And there's nothing turns on that because they're both in South Africa, but just as a something as an analogy.
I agree there completely. I think we're actually almost out of time, Trevor, but it's been a very interesting chat. And
it's a long case, but it's well worth interesting. And as you say, just to see how some people live, But he comes across as a very nice guy to whom his family was the most important thing of all. And at Tswalu, I've been to the Oppenheimer Game Reserve in Tswalu, and it's a wonderful. I've come back just to say goodbye to everybody. Thanks very much for watching. We reached the end of our time, so our session together ended rather abruptly, but we were more or less finished in any case. We'll be doing another podcast in approximately 6 weeks' time. Thank you very much for watching. Bye-bye.